Welcome to In Your Defense, Galveston and Beyond.
Welcome to the In Your Defense with Mark Diaz, a passionate criminal defense attorney with over 25 years of experience defending the rights of Texans. I'm Lisa Mosby, and today we're talking about family violence protective orders. Mark will go over what that means under Texas law, how they've been issued, and why they can have a major impact on a criminal case. Welcome back, Mark.
Hey, Lisa, thanks for having me back.
Mark, people often hear about emergency protective orders, restraining orders, or no contact orders. When someone is dealing with family violence situations, can you walk us through definitions for these so that we understand what they mean?
I can, and it's a touchy subject for me because they're overused in my county. Um, Basically, if you're accused of family violence here, no matter what the situation is, they're gonna put a protective order on you, and they're gonna put a day limit, typically 60 days, and it's no contact. They put, even if it's your home address, they put your home address. You can't go to your own home. You can't, and they put it in every domestic violence case, even when the victim didn't ask for it. So we have a lot of situations where someone gets arrested over a misunderstanding, and then on their way out of the jail, they're given this documentation telling them they can't go home, they can't call the victim. Many times it will also include if they have children, they can't have contact with your children. And then when they get out, they come to me, and then we have to try and unwind as much of that as we can, which is a process. Some judges, if they want it lifted, we have to have a hearing and bring in witnesses. And this is all before the case has started, all before I have a police report, any evidence, anything. Just because of the allegation, people find themselves literally homeless when they walk out of the jail.
And is it the same for a protective order as it is for a restraining order? They aren't allowed to go home.
So in the criminal justice system, we have two different orders that we use a lot. They call them an EPO, an emergency protective order. When we say restraining orders, that's typically in family law cases. That's not usually in criminal cases. We use the emergency protective orders for immediately upon your release from jail, right? Now, there are cases where we resolve a case by agreeing to a protective order, right? We'll agree to a protective order to not be around this person for, let's say, 2 years, right?
Mhm.
But initially, upon arrest, it's going to be the emergency protective order that affects the defendant. Restraining orders, like I said, they're used more in family law cases and sometimes to resolve criminal cases if the two people if the victim is happy with just having a restraining order, then sometimes we can do that, which is the same thing. It puts a distance marker, no contact, all that type of stuff.
So, Mark, these orders can be issued quickly and sometimes without the accused even being present. What tends to trigger an emergency order right after an arrest? You said it happens in all the cases. There is no trigger, or is there?
It happens in all the family violence cases where I practice. So if you get accused of assault on a family member, whether it be aggravated, non-aggravated, any type of assault, family violence, they are going to do an EPO. They don't ask witnesses first. They don't check with the victim first. They just do it. And then I have to try and unwind it if that's what needs to be done.
And then judges in Galveston, Chambers, and Harris counties all handle these differently. What factors usually influence the conditions they decide to put in place?
The problem is there's not necessarily consistency, okay? There's a blanket one, which is used most, and all courts accept it. But You may have certain judges that like another additional condition as a part of their EPO. And so you just have the key there is you have to know the judge and know what their normal practices are. It's almost the same with trying to undo certain conditions. Some judges, a written affidavit is enough. Some judges want the victim in court testifying, no, I do not want this protective order. But it, it it can get involved because imagine you've been accused of some type of family violence. You get out of jail, you have this EPO. You can't go to work if, let's say, your work computer is at home, your work laptop, anything you need for, let's say you're a tradesman and your tools are at home in your truck. Well, now you've just been told you can't go home. So we've done things as drastic as I've had to hire a private investigator to go to the house to get the items that we need just to go to work the next day, right? Uh, because me having contact isn't a violation of my client, and I'm not going to go do it myself. So I hired an investigator to go get my client's truck, work laptop, different things, just so he could function until we could get everything ironed out.
And then, Mark, a protective order can overlap with a criminal case, and then the two can interact in complicated ways. What are examples of situations where the orders end up affecting the criminal charge?
So there's actually more than one way. Some judges will take what was in the protective order and make them bond conditions. So the emergency protective order in the beginning that had a 60-day timeline on it, if the judge now makes some conditions of your bond, that means that those restrictions stay in place until the case is over. Doesn't matter if it lasts for a year or not. The other complication is if you get accused of a violation. If you get accused of a violation of the EPO, they can place a new charge on you, or the court can just choose to revoke your bond. So it's very important that people with any type of either bond conditions or EPOs be mindful of it. And if there's something we need to address, you need to let me know up front before it results in jail for any reason, meaning you lost your bond or they put a new misdemeanor charge on you, whatever it is. If you let me know in advance, I can usually address it. The problem is I have clients that just ignore them and get out of jail and go home, and that can complicate things.
What are some common situations where people unintentionally violate a protective order? And you've already shared one where they intentionally just disregard it. But I'm curious about unintentionally, because sometimes you don't really know if this is your first offense.
The most common unintentional violation is the victim, who is the subject of the protective order, says, I don't care about that. Come home. Or starts calling or starts texting. And then we start responding. That's violating the protective order because you're communicating with them. In other words, sometimes people have a hard time understanding that even if the person invites you over, it's a violation of your EPO. You cannot go. It's hard to get people to accept that, especially when the person's like, I didn't want this. I didn't ask for this. Just come home. Or, hey, I need you to come get the kids. I got to go somewhere. It could be something very simple. And if the state finds out about it, they can try to take action against you. And we've had that happen where, innocently enough, the prosecutor is calling a victim saying, how are things between you and, or whatever happened that night? And the person says, oh, everything's fine. We just had dinner together last night. It's like, well, hold on. You're not supposed to be together. Yeah, it happens.
So sometimes the person who requested the order wants contact again, just like you had explained, where they're texting or calling, but the order is still in place. Why does that create a legal risk if the two of them decided that it was okay together? And what is someone to understand before responding? Do you just ignore the text, not answer the call, or can you go back to court and do something about it?
We can go back to court and take care of it. The in 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 cases where it has been necessary, I have contacted the other person and explained that there can be no contact until I get this situation resolved. I can have them call me. Um, Again, like I said, I've had plenty of times where I made arrangements to send an investigator to someone's house to pick up belongings and then explain, look, Mark's going to take care of this, but until he does, there can be no contact and, things like that.
Okay. So you just have to reiterate, don't try to do it yourself. You just need to go to your lawyer. When someone believes the order is overboard, inaccurate, or maybe even based on incomplete information, what options exist to challenge or modify it?
So here's an easy example I can tell you that did happen. I had a client accused of domestic violence, and they happened to own two different properties. One was a woman's property before they got married. The other house was my client's property before he married this woman. But they each kept both properties. And so when they did the EPO, they got the addresses reversed. So they told him he could not go to this address, which was actually legally his house, but he could go to this address, which was actually legally her house. And so, yes, we had to go to court and get that, do a modification and put the addresses correct so each of them could be at the correct property. So it does happen, but it's just another one of those things. We can take care of it. I just need a couple of days. It's nothing in court happens overnight, but we can always get it done relatively quickly.
But we don't want to try to take it into our own hands because these are all legal matters. You need to go through the correct legal process, is what we're trying to.
Or you'll end up in handcuffs.
Yeah. So protective orders can include requirements that affect work, housing, family routines. You've mentioned them all. When you review an order for for the first time, what parts do you pay closest attention to?
Well, that's gonna depend upon my client's concerns, right? Um, since y you know, I live here in Galveston and I work here in Galveston, which is an island. So we have a lot of people that own more than one property. Maybe they own another property because it's a rental property. Maybe they have a beach house, what have you. So some people, when they get an EPO and it says they can't go to this address, they say, I don't care about that. I own another house over here. I'll go over there. So it's going to depend upon the individual person's needs. One that comes up a lot is going to be when the children are named or it's too broad and it says cannot go around this person or their family members. That could be interpreted to mean the children. And so many times we have to go just fix that and say, look, he or she needs to have contact with their children, but we're agreeing to stay away from the spouse, right? That one comes up a lot. And generally, most people, even victims, are good with that simply because you know how it is now. There's days mom can't pick up the kids from school, but dad can, or somebody needs to go to soccer practice and another kid needs to go to baseball practice. So a lot of times it comes down to family needs that require the most adjusting.
Let's wrap this up here. For anyone facing a family violence allegation, I think you've clarified the importance of following the protective order, and that is if you don't, you're going to end up in handcuffs. But what else is it that you would like folks to know if they might be experiencing this or in the midst of this right now? And can you talk about long-term consequences for these folks following a violation?
Well, the consequences following a violation are going to be handcuffs. That's the problem. The biggest thing that you need to consider is i- there's almost nothing we can't solve, right? Now, there could be a situation, and it's happened a lot, where a husband and wife get into a discussion one night and there's alcohol involved. They've been married for 30 years, never had an incident, and then something happens and the police get involved. But after cooler heads prevail, they realize they don't need any of this, right? And they try to just ignore it on their own and go about it, and that's when you could get into a violation. So the biggest thing to take away is if there's some portion of it that's a problem or negatively impacting your life, just let us know and let us take care of it. That way you don't have that hanging over your head. Because ultimately, if you were charged with a violation or your bond was revoked, that's a temporary custody situation. We can get you back out, but now it looks bad moving forward in the rest of your case that you violated the terms of either your bond or the protective order.
Thank you so much, Mark. I think what you do is bring a certain calm to these situations because of all your experience, your knowledge, and just how you make it seem so easy. We can get you out of it, but don't make the wrong action. So I just want to compliment you on how you treat your clients, and we appreciate all of your insights today. So thank you for that.
For having me.
That's it for today's episode of Defense on the Coast. To learn more or to get help with a family violence protection order or related criminal charge in Galveston, Chambers, or Harris counties, visit texascriminaljustice.com. And don't forget to like, subscribe to the show, and please leave a review if you found this episode helpful. We'll see you next time.
Thanks for watching. Be sure to hit that like and subscribe button and leave us a review in the comments.